Good afternoon, everyone. It gives me immense pleasure to be part of this master knowledge series, which I am so happy to see is attended by so many of you keen learners. Today's topic is AMLs and CFT guidelines under PMLA 2002. Friends, PMLA NV suggests certain record keeping and reporting obligations for financial institutions and persons carrying on designated business or profession. Persons carrying on designated businesses or profession are defined under PMLA. Friends, on February 3, 2003, SEBI published the guidelines on anti-money laundering AML standards and combating the financing of terrorism. These guidelines are intended to set out the steps that service providers shall implement to discourage and to identify any money laundering, terrorist financing, or proliferate financing activities. It prescribes the procedures and obligations to be followed by the reporting entities to ensure compliance with AML, CFT, and CPF guidelines. The main purpose of these guidelines is to understand and apply the risk-based approach and indicate best practices in the design and implementation of an effective risk-based approach. Identify the entities that conduct activities or operations relating to virtual digital assets, that is the service providers. The recent amendment of the Prevention of Money Laundering Act 2002 PMLA further underscores the crucial role that company secretaries play in ensuring compliance and combating financial crimes. The regulatory changes not only enhances the accountability of company secretaries but also underscores the trust placed in them to act as gatekeepers in financial system. The increased responsibilities also present challenges requiring company secretary to stay abreast of evolving regulations, develop a deep understanding of anti-money laundering practices, and implement robust compliance mechanisms with the organizations they serve. And with this intent, the institute is conducting today's session of E 4.0 Master Knowledge Series on the topic AML and CFT guidelines under PMLA 2002. Today, to deliberate on the topic of the sessions, we have with us two subjects expert, Ms. Rimjim Pandey, OSD Financial Action Task Force, Department of Revenue, Government of India, and CS Amita Desai, Practicing Company Secretary. It's a proud privilege to read their profiles in front of all our learned members. First speaker for today's sessions is Ms. Rimjim Pandey. Ms. Rimjim Pandey is an officer of 2016 batch of Indian Revenue Service and is currently posted in FATF cell, which is the nodal cell of for AML CFT coordination in the Department of Revenue, Ministry of Finance. She is a graduate of economics from Delhi University and holds a master's degree in public policy from National Graduate Institute for Policy Studies at Tokyo. Our second speaker for today is CS Amita Desai, practicing company secretary. Amita Desai is an experienced professional with over 3 decades of experience in company law, capital markets, FEMA, and corporate restructuring. Founding her firm, Amita Desai and Company in 1995, she demonstrated foresight in venturing into private practice at a time when very few did. Her groundbreaking spirit led her to scale up her practice in wide areas to provide solutions to business persons and corporates. She is a member of Secretarial Standard Board of ICSI for the year 2024. Uh, as an insolvency professional and CSR advisor, her firm focuses on due diligence, pre and post IPO corporate secretarial advisory, merger and acquisition, and guiding startups towards robust governance and compliance frameworks. Her widely read monthly updates and newsletters serves as invaluable resources for clients and professionals seeking insights into corporate compliance and governance. She is frequently invited as a guest speaker at prestigious forums such as ICSI and ICI. Her active involvement with NGOs underscores her commitment to societal welfare. It is our proud privilege to have two eminent speakers for today's session and get benefited from their word of wisdom in the arena of prevention of money laundering and money laundering. With their brief profile, we welcome them at the seventh session of EE 4.0 Master Knowledge Series and hope to have intense learning. All participants are requested to raise their queries, and same will be taken up either during the session or in the end of a presentation by speakers. Now I request Ms. Rimjim to take over the session and enlighten us on the topic. Welcome.
Thank you, Ashish, for elaborated reading out the profile. Thank you very much.
Thank you, Mr. Karodia, for the introduction. So I will put my presentation on screen. So today I will be talking about the AML regulatory framework, AML CFT regulatory framework, and obligations which are expected from the company secretaries. So first, AML, what is money laundering? That's a natural question which comes in our mind. So money laundering is I'll very briefly, I am sure most of us know what money laundering is, but I'll very briefly take everyone through money laundering. So money laundering is a process of concealing the origin of money obtained from illicit activities like drug trafficking, bribery, fraud, corruption, and there is a plethora of other activities which we call in our Prevention of Money Laundering Act as predicate crimes, which can be the origin of the illegal proceeds. So the purpose of money laundering is to introduce illicit funds into the financial system under the guise of clean money so that criminals can use it without attracting undesirable attention from authorities. The fight against money laundering is often linked to efforts against terrorism financing because both ML and TF involve redistribution of the funds. And there are three stages of introducing laundered funds into the financial system, which is the placement, layering, and integration. So what is Financial Action Task Force? We all know that we have come under the ambit of certain regulation of the ICSI as a self-regulatory body and even as FIU. But where does it all come from? Where does it all emanate from? So it's from Financial Action Task Force. It's an independent intergovernmental body that develops and promotes policies to protect the global financial system against money laundering, terror financing, and financing of proliferation of weapons of mass destruction. FATF has a set of standards and immediate outcomes which the member countries are expected to follow, and they are also evaluated on the basis of those set standards through a peer review process. And India is in the process of its own mutual evaluation, which will be concluding in another month. So we are in the fag end of our process of mutual evaluation. So I will just briefly take you through what FATF and its mandate is. So it's an intergovernmental body which sets international standards that aim to prevent the illegal activities which we just talked about and the harm they cause to society. As a policy-making body, the FATF works to generate the necessary political will to bring about national legislative and regulatory reforms in these areas. It's a 39-member body which sets international standards to ensure national authorities can effectively go after illicit funds linked to drug trafficking, illicit arms trade, cyber fraud, and other serious crimes. In total, more than 200 countries and jurisdictions have committed to implement the FATF standards as a part of their coordinated global response to preventing organized crime, corruption, terrorism, and other economic offenses. Although the members of FATF are just 39, but there are certain other regional bodies which derive their structure and organization from the FATF, from the main body. And there are regional bodies like the Asia Pacific Group and the Eurasian Group and other groups like that. So these are the... is my PPT visible? Because I just got a...
No, not visible.
Okay, let me just... We haven't lost on much because I'm on the very first slide only. I'll just try to share it again. Is it visible now? Okay. 1 second. I'll put it on the slideshow mode. Yeah.
Yes, it is visible.
One
Please.
second, I'll put it on the slideshow mode.
Rimzim, go on the bottom and the fourth icon. For plus
Yeah, but it's
minus,
not, I'm not able to because there's some, 1 second.
where there's a plus and
Yeah.
minus sign, before that there is a
Yeah.
yeah, that's correct.
1 second. Okay, so although the members are just 39, but there are other sub-regional groups which also follow the same standards and the same structure of organization as the FATF. It was established and it's headquartered in Paris. So what is the mutual evaluation process? So FATF mutual evaluations are in-depth country reports analyzing the implementation and effectiveness of measures to combat money laundering, terrorist and proliferation financing. The reports are peer reviews, as I just spoke about. Peer review means that the other members of the FATF, they give their own assessors, like uh, we being part of FATF cell and being a part of the machinery, we also go to other countries and assess their AML process. So we are sent as Indian representatives as a part of the assessment team to other countries. Similarly, India's assessment team also comprised of members from different countries. There were around 12 members in total. So they analyzed and reviewed the entire process, the AML CFT CPF process of India. So mutual evaluations, they provide an in-depth description and analysis of a country's anti-money laundering and counter-terrorist financing system, as well as focused recommendations to further strengthen its system. During a mutual evaluation, the assessed country must demonstrate that it has an effective framework to protect the financial system from abuse. It has two components, the technical compliance assessment and the effectiveness assessment. I'll not read the entire thing. So the technical compliance talks about how the country has developed its system, how it has come out with laws and regulations to follow the standards, FATF standards, and the effectiveness shows whether the set standards, which are already evaluated as a part of technical compliance, are effective. So these are the two aspects of the mutual evaluation process. Yeah. So risk and context. So the standards are the same for all the members, right? But all the countries are different. Some have common law, some have other kind of systems, some are still monarchies, some are a parliamentarian form of government. So every country is different, but the standards are the same. So there is some there would definitely arise some issue in application of the same standards to all the countries. So here is where the risk and context of every country comes into play. When the assessment team assesses a country, they have to consider the risk and context of that particular country. So the assessors have to initially understand the country's risk and context in the widest sense and elements which contribute to them. This includes the nature and extent of the money laundering and terror financing risks, the circumstances of the country which affect the materiality of different recommendations, structural elements which underpin the AML CFT system, and other contextual factors which could influence the way AML CFT measures are implemented and how effective they are. For example, a country, a small country in Europe, or maybe a country like Japan, may not be as relevant for terror financing as, let's say, a country in the Middle East. So this is where the context comes into play. The risk assessment of that country and how contextual is that risk comes into picture. So what does the FATF require in evaluation of this risk and context? So the country should identify, assess, and understand the money laundering and terror financing risks of the country. And based on that assessment, competent authorities, financial institutions, and DNFBPs should apply a risk-based approach to ensure that AML CFT measures are commensurate to the risks identified. Where countries identify higher risks, they should ensure that the AML CFT regime adequately address those risks. and where they are lower, the application of the addressal of such risk should be commensurate. So this has already been discussed. So what forms the basis of the risk assessment? It's basically the data which is collected by the National Crime Records Bureau, data on money laundering cases investigated by the Enforcement Directorate, data of terror financing cases investigated by the State Police and the National Investigation Agency, typology of cases investigated by law enforcement agencies and the State Police, the suspicious transaction report which are filed by the FIU, and their trend analysis, operational analysis, and formal and informal cooperation requests from other countries in the form of either through informal channels like Egmont or through formal channels like extradition or mutual legal assistance treaty. And the threat has to be assessed in a particular manner. So similarly, we have terror financing threat in India. There are 6 theaters of conflict which have been identified as a part of the terror financing threat in India, which is Kashmiri militancy, radical Islamic terror, radicalization, Northeast insurgency, left-wing extremism, and pro-Khalistan extremisms. So what are the modes of terrorist funding in India? So it's state sponsorship, organized through organized criminal gangs, extortion through non-profit organizations, fake Indian currency notes, narcotic financing through virtual assets and other crowdfunding sort of platforms, and illicit arms trafficking. So what are the mitigation efforts that have been taken by India? So as we know that India has a zero tolerance policy against terrorism and has taken various measures to mitigate the risk emanating through terrorist financing, which includes the institutional mechanism, the interagency cooperation between the various agencies which are working towards maintaining law and order, capacity building workshops, international cooperations, work which is being done on non-profit organization. For narcotics financing, we have a Narcotics Control Bureau for that. For virtual assets, Kashmir militancy, we have the J&K police and other specialized wings of the J&K police, as well as the state National Investigative Agency, to curb illegal and unlawful activities in Northeast states, measures to combat left-wing extremists, and to counter radicalization in respect of pro-Khalistani extremism, and other measures to counter terror financing. So in the context of India, the overall national risk from terror financing has been assessed as medium. Now we come to the main part, which is the designated non-financial professions and businesses. So basically, the FATF recognizes the financial. There are 3 aspects to the regulation and supervision standards and the outcomes which FATF prescribes. So one is the financial institutions, which covers banks and other financial institutions, the securities market, and payment aggregators, and every other thing which is regulated by the RBI, SEBI. They are a part of RBI, SEBI, PFRDA, IRDAI, IFSC. They all are part of the financial institutions. Now, there are other designated non-financial professionals and businesses which have been designated by FATF as being high risk or maybe relevant, not just high risk. Every designated non-financial professional business is not high risk, but they are relevant for money laundering threat in India or across the world because of being professional gatekeepers. So according to FATF, there are many DNFPBs like casinos, real estate, dealers in precious metals and stones, accountants, etc. There are 3 types of accountants professionals in India: members holding practice from ICAI, ICSI, and ICWAI. The central government-wide notification dated 3rd May 2023 notified the above 3 accountants professionals categories as reporting entity under Section 2(1) SA of the PMLA. Now, what are the ML threats, vulnerabilities, and mitigation measures which have been identified in the National Risk Assessment of India pertaining to the DNFPB sector? In the threat assessment, it was recognized that the AML CFT controls are in place across sectors and they have been found to be effective. However, there are some apprehensions in some associated with the business and professions relating to the real estate sector because of the sheer magnitude and the use of cash in the sector. Then again, gems and jewelries because of the amount of consumption of precious metals and stones in India, casinos and other professions. So I think I have covered these vulnerabilities as well. So what are the mitigation measures in the real estate sector? We have the documentation proof requirement. Income tax requires that Section 50C of the income tax requires a certain calculation and computation of capital gain arising out of this thing, real estate transaction, and also the filing of the SFTs by the registrars is also a part of the same setup. Further, the Benami Property Transaction Act, which criminalizes Benami ownership of assets. And then coming to the gems and jewelry sector, there's a mandatory reporting of cash transactions above INR 10 lakh. Cash receipt of 10 lakhs are prohibited under the Income Tax Act. Transaction greater than 2 lakh through other channels quoting PAN is mandatory. Gems and Jewelry Export Promotion Council has been set up as the apex body. And then there's hallmarking requirements and due diligence have to be taken while recruiting staff, etc. Similarly, in casinos, we have casinos only in a few states in India. So their licensing departments and the Department of Tourism have taken adequate measures to ensure that the sector is well regulated and are complying through all the AML CFT measures. Similarly, for the other professionals, we have the FIU and as well as the self-regulatory bodies, which are the institutes of all three bodies as the statutory professional bodies for regulating and developing the professions in India. So what are the recommendations? What are the FATF recommendations which are pertaining to DNFPBs? So I will go, although there are a lot of other recommendations and a lot of cross-cutting issues, but the three main recommendations are recommendations 22, 23, and 28, and specific elements of recommendations 6 and 7, which relate to designated entity, terror financing sanctions and proliferation sanctions. And although these are the main entities. So the requirements of recommendation 22 regarding customer due diligence, record keeping, politically exposed persons, new technologies, and reliance on third parties are also set out in recommendation 10, 11, 12, 15, and 17, and they apply to accountants in certain circumstances. I will be sharing the presentation, and even you can find the FATF methodology online. It's publicly available online, and these recommendations can also be referred to. So specifically, the requirements of R22 applies to accountants when they prepare for or carry out transactions for their clients concerning the following activities. This has also come out in the 3rd May circular guideline. Buying and selling of real estate, managing of client money, securities or other assets, management of bank savings or securities accounts, organization and contribution for the creation, operation, or management of companies, creating, operating, or managing legal persons or arrangements, and buying and selling of business entity. Just a yeah. So further, recommendation 23 requires that recommendation 18, 19, 20, and 21 provisions regarding internal AML CFT controls, measures to be taken with respect to countries that do not or insufficiently comply with the FATF recommendations, reporting of suspicious activity and associated prohibitions on tipping off and confidentiality apply to accountants when on behalf of for a client, they engage in a financial transaction in relation to the activities described in recommendation 22 above. I believe Ms. Amita will be taking you through all the other requirements which are set up in the guidelines issued by the government, the 3rd May guidelines. So I'll very briefly touch upon the requirements which FATF has mandated for us. So, what are the legal framework relating to client due diligence, which comes under Recommendation 22? Section 11A of PMLA mandates that every reporting entity shall verify the identity of its client and the beneficial owner by one of the methods prescribed therein. Further, Rule 9 of PML rules provides detailed guidelines in this regard. You can read the Prevention of Money Laundering Maintenance of Records Rule 9, which particularly sets out the client due diligence requirements from each of the category of clients. So accordingly, DNFPVs which are reporting entities under PMLA are subject to all the requirements mandated under PMLA with respect to client due diligence, and in addition are required to comply with any additional requirements prescribed by any other law or regulation or guidelines issued by respective regulator. What are the other measures under Recommendation 23? So 23.1 talks about the suspicious transaction reporting. And this comes under Rule 8.2 and Rule 3.1 of the PML rules. So it deals with the maintenance of records of transactions and suspicious transactions and their reporting to the FIU India. So as now the accountants have been notified as reporting entities, so they are now duty bound to report certain suspicious transactions to the SRB, which further translated to the FIU. So these are elaborated in Recommendation 20 in respect of all reporting entities. The said rules are applicable to DNFBPs, which are reporting entities. 23.2 talks about the internal control requirements, which is translated to Rule 7.3 of the PML rules. It deals with the internal control requirements for a reporting entity. These are elaborated in Recommendation 18 in respect of all reporting entities, and the said rules are applicable to DNFBPs, which are reporting entities. Higher risk countries, Recommendation 23.3, Section 12AA of the PMLA. It provides for enhanced due diligence measures for higher risk clients, business relationship, and transactions, irrespective of their geographical settlements. Then 23.4 is tipping off and confidentiality requirements. Section 12A3 of PMLA provides that the information which is furnished to the Director FIU India shall be kept confidential. So now from the 3rd May notification, we all know that company secretaries who now hold a certificate of practice are notified as reporting entities under the PML rules. Accordingly, all the requirements enumerated in the previous slide in the legal framework under the PMLA and PMLR would be applicable to them. And they are also required to adhere to the Code of Conduct rule prescribed by the self-regulatory body. Now coming to the Recommendation 28, the chartered accountants, company secretaries, cost accountants are registered and regulated by the respective self-regulating bodies constituted under different statutes. In addition, Director FIU in shall also supervise for the purpose of monitoring, ensuring compliance of DNFPVs with the AML CFT requirements. The licensing and registration requirements are laid down in Section 4, read with Section 8 of the Company Secretaries Act 1980. The ICSI had issued an advisory on 13 December 2022 is what I got to know to all its members for observing compliance to various applicable PATF recommendations. So this is the document which Ms. Amita will be taking you through in detail. This is the guidelines which has been issued by FIU, and it talks about the requirements. It's a 15-pager document. It talks about the general obligations from relevant persons as notified. And we can take the questions later in the question answer session. And now I pass it on to Ms. Amita. Thank you.
Thank you very much, Rimzim, to set the tone and understand for our members about FATF and what are the recommendation and expectation of the country in this respect. I'll just share my screen, and I thank first of all to ICSI to having me here and interact with our client, our members. Just sharing the screen. Is it visible? Sorry. So We are talking today about Prevention of Money Laundering Act, and I am sure that many of our friends, company secretaries, and professional chartered accountant, they are just wondering how this is applicable to us. So I think we have to keep our mind open, find out what are the happenings around internationally and national, and understand what are our roles. So I think already Rimzim has set the tone and make us understood what is PMLA. But to take you through what when this act was enacted in India, it was enacted long ago in 2002, and it was made effective from 1st July 2005. Even the rules were also notified effective from 1st of July 2005. And in the year 2004, FIU India, that is Financial Intelligence Unit, was also set up in 2004 in India to monitor, control, and to guide and maybe for more enforcement also about the compliance of this AML law in India. What is money laundering all about? I think that also Rimzim has broadly took us through that money laundering is why it is a serious issue, because it is making a whole process whereby the illegal or illicit money which has been arise from the crime, terrorism, corruption, trafficking, human trafficking, all the illegally obtained funds appear to be legal, and it is come into the mainstream of the finance, and it will make them as if it is a legitimate source. And that's the worry for every country, every nation. And that's how the money laundering is all about in general. When it becomes an offense, that we need to understand under Section 3 of the PMLA or the Act, it defines very clearly that whosoever, directly or indirectly, the important word is directly or indirectly, attempts to indulge or knowingly assist or knowingly is a party or is actually involved in the process or activity connected with the proceeds of crime. Now, this proceeds of crime word is also very important. We have to understand. In the next slide, I will take you through what do you mean by the proceeds of crime. It includes not only this concealment, but possession, acquisition, use, projecting, or claiming it as an untainted property. And the explanation also says that this process or activity is just not one time, but it will be a continuing activity till the person is directly or indirectly enjoying the proceeds of crime. So till that time, you are also part of under the offense. The definition, as I say, the proceeds of crime is very important, and we as a professional always wonder how come we become in the part of the crime, but unknowingly, unknowingly, directly, indirectly, there could be a chance. So if the definition is followed from the act itself, it defines that the proceeds of crime means a property derived or obtained directly, indirectly by any person as a result of criminal activity relating to the scheduled offense. We'll take you through the scheduled offense under the act, or any value of such property, maybe properties taken in India or outside India. That is also the entire amount is the proceeds of crime. And the most important part in this definition is an explanation. Explanation says that this money or the proceeds of crime also include any such property which is derived from any activity which is a criminal activity, but it is relatable to the schedule offense, not relating. This one word under the main definition is a relating to the schedule offense. In the explanation, they are also saying that relatable to the schedule offense. And what we will see the what are the schedule offense. The schedule offense was also defined under section 21Y of the PML Act, and it defines into three parts, A, B, C. In part A, there are 29 legislations which are enlisted under which section of this law it will be considered as an offense under this act also. So the laws are, I'm not identifying all 29, but broadly, Indian Penal Code, unlawful activities, and the Arms Act, SEBI Act, Customs Act, Environment, and funnily, there are Copyrights and Trademark Act also is involved. And of course, there is a provision under Section 447 of the Companies Act where there is a criminal offense, and that is a scheduled offense under the PMLA also. So if it is relatable to this and relating to this act, all these sections, then also it is a criminal, it's a proceeds of crime. Part B is also under the false declaration and the false document under the Customs Act. Part C is a cross-border implications of offenses. So these are the schedule offense which has been identified, and if you are doing any of this relating to or relatable to it, it will be a proceeds of crime. Now we'll talk about what would be the meaning of reporting entity. So reporting entity is also defined under the Act. Why we should understand reporting entity? Because we as a professional are also now being informed that you are also becoming a reporting entity. The definition reads under section 21 WA of the Act, it reads banking company, financial institution, intermediaries. Intermediaries are all which are registered under Section 12 of SEBI Act, like maybe we can say the stock brokers, stock exchange, then depository participants, and FPIs. All those people are also associated as the intermediaries. Or it also says, or a person carrying on a designated business or profession, which is very important for us to know that. We will take you in the next slide. But in this definition, it has been covered what are kind of the businesses. So, person who is carrying, playing a game of chance like a casinos, Rimzim has also explained that. Inspector General of Registration, real estate agent, dealers in precious metals and precious stones and high value goods, person who are engaged in safekeeping and administration of cash and liquid securities on behalf of other people. And the last one, which I have highlighted in yellow, is a person carrying on such other activities as the central government may notify. And that's how 3rd May 2023 notification has come from this power. The central government has been given power under the Act that they can notify anytime later in the for the implementation of the law to identify any class of any person who is carrying a certain kind of entity. And there are many obligations, believe me, for a reporting entity, and so we should be more vigilant. There are special codes also under Section 43 of the Act that will be already that is the special code which will be taking care of the any prosecution or anything to for the offense committed under the PMLA. We'll not go in detail about Section 43, but the codes of session are designated, and currently, as my understanding, as per 2019 public domain, I have read that there are 66 special codes are designated by government. We'll also understand some of the rules. We understood some of the provisions of the Act. Now for the rules, which is also very small rule, and number of sections are very small, but there are elaborated details are given how a person should be maintaining the records. So there is a definition under the rule about the designated director, designated officer, non-profit organization, principal officer to be appointed by any reporting entity, KYC, and what kind of records to be made available or to be documented and maintained also for a number of years, maybe 5 years as per the Act. And what is the definition of transaction and suspicious transaction? And the rule further provides about how a person should maintain the entire record of transaction. Suppose you are taking care of some transaction of a corporate action for equity allotment, then you have to maintain if there is a coming from the high risk jurisdiction or you feel that there is a suspicious transaction, you have to maintain the record. So it talks about the maintenance of records containing what kind of information it should have and how the in what manner you have to record the information and maintain it, and how do you furnish information to SRB or maybe for some professional or others which are not so far identified directly to the FIU IND. And there's a client due diligence and enhanced client due diligence also. Appointment of a designated director, principal officer, and their nodal officers. Everybody is to be with their name, address, email ID should be reported to FIU IND. We will also see two definition only and the rules. One is a transaction, another is a suspicious transaction. So transaction is also defined clearly under the rule 21H of the PMLA rules, and it talks about any purchase, sale, loan, pledge, gift, transfer, delivery, or the arrangement thereof includes opening of an account, deposit of any funds in or transfer of the funds in currency in the electronic or physical means, use of safe deposit box in or any other form of safe deposit, and entering into any fiduciary relationship or a nomination. You can or you can have a power of attorney on behalf of somebody. These are all transactions. Any payment made or received or in whole or in part in any contractual or legal obligation by anybody. Any payment made in respect of playing of games or casinos, establishing, creating legal person or legal arrangement. These are kind of a transaction which we should be aware of. And we will also see what is a suspicious transaction. That is also been defined under Rule 21G of the PMLA rules. It says a transaction or attempted transaction. The highlighted is even if you try to attempt, you may not be successful in the transaction completion. But if any transaction or attempted transaction, whether or not made in cash, which to a person, a normal person acting in a good faith, first it will give to rise to a reasonable ground of suspicious that it may involve the proceeds of crime, regardless of the value. Maybe the value is small, but you have a reasonable ground of doubt as a reasonable, normal in the person acting in a good faith, then it will be a suspicious transaction. Second is appears to be in the circumstances of unusual or unjustified complexity. There are chain of corporate structuring, and you find that really is it required, and that may be for eye washing somebody. So that will give some doubt to you, that will consider as a suspicious transaction. Third is if it appears to you that there is no economical rationale or bona fide for doing this. If you are giving at a throwaway price some loan to somebody, or there is a contract, or you are transferring the money at a, or buying something at a very huge price without any having any rationale of economic value of that goods, then it appears that is it a sham transaction, is it a eye washing of something, and whether is there any other purpose. So that gives some kind of a suspicion. D is one more, give rise to a reasonable ground that this financing is maybe from the activity relating to the terrorism. So these are all giving some suspicious transaction, which there is an obligation as a reporting entity will go through later, that it will give obligation for us to report to our institute. Moving next is a what is FIUIND, as Rimzim again explained in detail about. It's a national agency which has been set up by Ministry of Finance, and it will be responsible for coordinating and strengthening the efforts of India and international intelligence, and for combating of money laundering and terrorist financing and proliferation of the finance. So that's FIU. Again, we will not touch on detail because FATF has been elaborated discussion happened with by RIMZIM. So it is found in 1989, 200 countries. India has been granted membership in the year 2010, and there are a number of recommendations by FATF to whereas we have complied, as far as my knowledge, 109 recommendations. The company India has, India as a country has followed. And if there is no compliance of this recommendation, then there will be a definitely impacting on the rating of the country, and accordingly the finance or the foreign money in the corporate market or in the stock market will be definitely affected, and thereby the country's conduct of business is also impacted. So we all, or the nation's main priority is to comply with all the recommendation which FATF is prescribing on mandating. So some of the recommendation already RIMZIM has took us through 22 and 28, 23. So broadly, essentially, the recommendation set out essential measure of the country that every country should have in place for any kind of this transaction to avoid any money laundering or financing, terrorist financing. So first, identify the risk and develop the policy. Second is pursue all this proliferation of this, how it happens, apply preventive measure, have the power and responsibility in our competent authorities of, like we have FATF or Enforcement Directorate, MCA also, because of the beneficiary ownership we are all aware about, we have to file Ben 1, Ben 2. So there has to be a responsibility to be given to the competent authority. Enhance the transparency and availability of beneficial ownership information at the real time and available at any point in time by the nation, and facilitate international cooperation and exchange of information to each other country. And that these are all recommendations. RBI has already given a master circular in 1st July 2008 and recommended, because number of times this act has been amended from 2002 to 2008. So RBI has issued a master circular to bring everything at par, and they gave the instruction to financial institution to follow about the KYC norms, how the bank should take before they induct any a new client. And that link is also given here, which you can, I'm sharing my PPT also, so you can share, go through this link. So we'll come to the main topic, why suddenly it become a buzzword in our professional community. Because the act has always been applicable, mostly we are aware that it is applicable to banks, NBFC company, intermediaries, stock exchange, crypto exchange, intermediaries, as we discussed about the stockbrokers and depositories, share transfer agent, foreign portfolio investors, trust and NGOs also. So suddenly why it is now applicable to us. So India has recently amended this, and company secretaries, even the directors, apart from the independent directors, accounting professionals, they all are coming under the net of this PMLA, because if they undertake certain financial transaction. Now we'll come to that, what kind of that certain financial transaction make us as a reporting entity. So that's the main sudden boom in the buzzword of this. we'll just take you to that background that why this notification has suddenly come. So in the recent past, some professional has assisted in a case in the some shell companies they have formed, and they become a director also, a dummy director. They have given access to the and operating the bank account also on their behalf. So that's how now the professionals are also required to perform a due diligence, because that indirectly, directly, knowingly, unknowingly, they become a part of the scam. And that's how we are being responsible as a professional, because we take, like for a company secretary, the first person to set up a company, to bring the subscription money, to open a bank account. Then we are managing, we are doing buying and selling of entities also on behalf of our client. So these are all kind of a cause where the money will come into the system, and money laundering act will be definitely triggered. So what additional due diligence we have to perform, what kind of documentation we have to keep, when we should be more alert and vigilant to find that there is a really suspicious, and if we have a little bit of doubt, we should immediately report to our respective institute. That's the background. So Section 2(1) WA, we saw that reporting entity is already been defined under the Act. Section 2(1) SA also of the Act defines person who are carrying on designated business or profession. So the Ministry of Finance has given two notifications. One is May 3rd, 2023, and second is May 9, 2023, which are very, very important, and that has widened the scope. So one on May 3rd, it has come that who are those people who are undertaking financial transaction on behalf of client or any other person. They are under the purview of this Act. And 9th May 2023 says that certain activities are being defined. If we are doing on behalf of anybody in the process or in the course of our business or profession, then we are also brought under the ambit of Act. So we as a professional doing some financial activities, like practicing chartered accountant, cost accountant, and company secretary. So main word is a practicing person, not who are in the employment, but who are having the certificate of practice issued by the respective institute. And there is one other word attached to it, and they provide certain financial transaction on behalf of their client. Then only they become a reporting entity. So before this notification of 3rd May, following are all on the left side, there's a bucket list who are the reporting entity as per the original PML Act. This we are not repeating, but that Rimzim is also explained, and I have also mentioned in earlier slide. So now after the notification, practicing chartered accountant company secretary will come who are carrying out financial transaction on behalf of their client for certain specified activities. So what are those activities has been defined under the 3rd May notification is first, practicing CACS or through their firm if they are doing during the course of their business or profession, buying and selling of immobile property for and on behalf of their client. Of course, you have to read that. Second, managing of client's money and client security. That means you are operating the demat account of the client or any other assets also. You are holding on behalf of your client and you are managing that. Third is the management of the bank account, saving account, or securities account. Next is the organization of contribution that for the creation or operation or management of the company. Now here there will be definitely a lot of question by a company secretary. How can I say that if I am organizing contribution for the creation? So if there is a new company which is being established and you are supporting your team members, your known person, that they will subscribe for your subscription money, that means you are doing on behalf of company and you are allowing and managing contribution for the creation of the setup of the company, or you operate the company with the power of attorney, or you manage the day-to-day affairs of the company as if it is yours, though it's in the behalf of a client through the power of attorney also, then you become a reporting entity. And I'm sure there will be number of questions on this particular leg, that how a contribution of creation, operation, and management of the company will be a reporting entity. We'll definitely go through in detail later. The next bucket is a creation, operation, or management of the company's LLP or a trust, and buying and selling of business entity. So buying and selling of business entity, we definitely do a lot of time transaction, restructuring, demerging. So whether this will also be covered, that's a question we will discuss. Now creation means incorporation of a company LLP, and buying and selling of entities means involved in transaction of change in control also, if there is a change in control. That is also covered under this So creation would be definitely a lot of question on creation of the LLP and company. Even NGO as a trust, you become a trustee. Then also you will be triggering yourself as a relevant person. Moving next, I think I have put some example. We'll discuss later also in the FAQ. So broadly, which are these financial transactions that if a professional is doing during in the course of his profession will trigger him as a reporting entity. So buying and selling of immovable properties by you arranging your finance and you becoming party to that. You are a signatory and you are taking care on behalf of client. That also makes you as a reporting entity. You are aware about the entire transaction, and if there is any suspicious transaction, definitely you being a professional, you have to report to suspicious transaction report STR to your SRBs, which is the institute of the respective institute. Operating your client's bank and demat account, operating bank account of client, arranging the subscription shares, controlling operation, buy and sell of business. I think I already discussed about this. Uh, these are some example which makes you as a uh, reporting entity, but there is some sign of relief. Like practicing company secretary is to take note that if charging professional fees for government fees, payment to the Ministry of Corporate Affairs, or your legal dues of your fees would not make you or construed as a financial transaction and does not make you to be a reporting entity, because you are just facilitating to form a company and allow and declare or provide a certificate also that company is in compliance or LLP is in complete compliance, does not make you in a position that you will become a reporting entity. And this is the most common question will come to all PCS, that by formation of a company, am I being a reporting entity? Similarly, for any chartered accountant, the core function of the chartered accountant is for audit purpose, assurance, providing report of due diligence, taxation. Whether this will constitute, answer is no. These are their core function, does not make them as a reporting entity, because these are not financial transactions. Now coming to the next notification, which has come on 9th of May by the Ministry of Finance, it has further broadened the law and bring certain activities in the ambit of PMLA. Now, what are the during the course of business, what activity a person will do? Like first, acting as a formation agent of the company. Now, formation agent is not defined. So, we as a company secretary are not a formation agent if we are professionally certifying something and forming a company. But the formation agent is not somewhere defined. But we'll come to the clarification which our institute has given, that by charging government fees and legal fees of professionally for formation of a company does not make us as a you are into the acting as this activity. We are not doing this activity. We are just facilitating to company to carry out their activities. So we are acting as a formation agent or not. Maybe we'll go back to the to RIMZIM also later for FAQ to clarify what do you mean by the formation agent, because it is not a defined term, but the institute has very clearly defined it. So second is acting as a director or a secretary of such a company or a partner of a firm or similar position in relation to other companies and LLP. And then this is a certain kind of an activity which will make you as a reporting entity. Similarly, providing a registered office, providing business address, accommodation, correspondence or administrative office address to the company LLP, you are putting yourself into a reporting entity, because you are providing your register office. Two foreign companies are asking to form an Indian company. They do not have a register office, so they you provide as a facilitating. Okay, for the time being, you use my office as a register office. You are putting yourself into the PMLA jurisdiction, and you become a relevant person and reporting entity. Similarly, acting as a trustee in any kind of a trust, maybe Section 8 company or any other trustee or express trust, and performing equivalent function for any other type of trust. Again, you become a reporting entity as per 9th May notification. And last one is acting as a nominee shareholder for any other person. You are putting yourself into again a kind of an activity. And here there is no threshold value has been prescribed, because if you conduct any of this activity, even if you have given your register office free of cost, the value is not important, but you have facilitated for doing something, or indirectly you have been in the proceeds of crime, if that comes into, and that's how we are into the ambit of PMLA. So we have to be very careful. Now, in the 9th May notification, Ministry of Finance has given excluded activities, that what activities if you do will not be putting you under the reporting activities. So if you are giving your register office on lease, sublease, tenancy agreement, and you are taking a TDS, also deduction of tax, and reporting to government, then you are not carrying out such kind of an activity. You are not under the ambit of under this notification of 9th May. Secondly, any activities carried by the employees on behalf of employer are not also covered under this. Activities here it is very clearly mentioned that activities that is carried on by advocate, company secretary, chartered accountant, and cost accountant in practice who are engaged in the formation of the company to the extent of filing a declaration of compliance of the law with the registrar of companies, that will not put you into the carrying out that kind of activity as per 9th May. So you are exempted. Similarly, activities by an intermediary which is already under the PML Act. So again, 9th May, they excluded that they are stockbroker, recognized stock exchange, other registered intermediaries as per Section 12 of the SEBI Act, already covered under the PMLA. So those activities are not part of 9th May 2023 activity. Certain further example of exclusion is given like insolvency professional and liquidator who are doing that activity as a part of under the Insolvency and Bankruptcy Board of India or IBC code. They are also exempt. Nominee director, independent directors are exempt. Charging professional fees for government and legal dues are also exempted activity. Which are the included activities are you are carrying out financial transaction on behalf of your client, having power of attorney, project financing, recovery consultant for the banks, and organizing contribution for a dummy shareholders or dummy lenders for the company, acting as an executor or wills if the client relationship is established. All those are included activities as per the 9th May notification. Now we'll touch upon the main guideline of AML and CFT of 19th June, effective from 19th June 2023. This guideline has been issued by FIU IND and it was giving all controlling about summary of the legal provision and what are the expectation and legal obligations of a professional. So this law or this guideline touch upon three law, Prevention of Money Laundering Act, Unlawful Activities Prevention Act, and the Weapons and Mass Destruction and Delivery System, the long name of the act. And we were all wondering what is this weapons of mass destruction, which is 1967 2005 Act, and unlawful activities are 1967, and why it is applicable to us, because now we are becoming a relevant person for carrying out certain financial transaction on behalf of the client. Now, what are SRBs? SRBs are these three institute to whom does the information has to be submitted by a professional practicing CS, CS or ICW. They have to report any suspicious transaction, due diligence, everything they have to do, and SRB is their respective institute. The question may come that the professional is a CS, CS and ICW. Which institute he has to report to? That a professional has to decide what kind of services he has provided to the client, and accordingly he can find whether I should report to ICSI or ICAI or ICWAI. Moving next, what are the expectation or under this guideline, what is mentioned about the SRBs, that what they have to do. So SRBs are our institute, respective institute of company secretary, chartered accountant, and the cost accountant. They have to perform supervisory, advisory, and monitoring function. Each SRB need to appoint a nodal officer. I'm just touching upon this a basic that what ICSI would be doing for us. They will be having a nodal officer. Institute will constitute a permanent technical committee to identify that relevant person is holding a certificate of practice or not. SRB also to send a detail of nodal officer and head of technical permanent technical committee to FIU IND. They have to monitor if there is a reporting entity about its all conduct and reporting on-site and off-site by supervising. SRB also need to give a guidance to the members if on filing of STRs. STR is a suspicious transaction reports, and then in turn they will file to FIU IND. SRB also need to give guidance to the members about the procedure of KYC. What do you mean by the client due diligence, enhanced client due diligence? What are the sanctions screening? What are the KYC or what are the documentation you will do on onboarding of the new client? What is your existing client's review also? What kind of record keeping you should do? What kind of transaction monitoring, suspicious transaction or monitoring, reporting, keeping not tipping off to anybody? All this guidance will be given by the institute. Institute will also take necessary steps by spreading awareness, like organizing such kind of seminars, webinars, so that our members are aware about their obligation and encourage the compliance also. Now, Coming to the our obligation under the guidelines, it says that the practicing CS, cost accountant, chartered accountant who are considered now as a person carrying on designated business or profession, they become automatically a relevant person and reporting entity. And what are requirement from them? So where there is, so these are our obligation. When we have a reasonable ground to suspect that any transaction by our client, funds are coming from the proceeds of crime, or we are not very aware and very much doubtful. There is a doubt that there could be a suspicion. So on some transaction, we feel that I don't know why the money and from whom it come, or the beneficiaries or ultimate beneficiaries are not being disclosed to us. That is a reasonable ground. We can definitely ask the client first. If we find that there is no such disclosure are being given by them and there is a kind of a suspicious transaction, we form as an opinion, we should definitely report immediately to our institute as an SRB within maximum 7 working days. And we have to develop internal mechanism to be aware about any kind of a cash transaction, any kind of transaction with the NGO, suspicious transaction, cross-board transaction where there is a immovable properties are involved, or huge amount of the equity transactions are happening. No reason there is a transfer of shares, transfer of the new person will come in. Or in case of an NGO, there could be a donor and you are just surprised at how this money is coming. Not very well sure, then you should definitely, it will give a ground of suspicion and reporting. These are the general obligation. First and foremost, if we find that we become a reporting entity, we have to first do registration with our institute, and institute has given a separate email to every member, all 60,000, 70,000 members, and put a separate portal of PMLA portal. And our duty is to first register as a reporting entity. After reporting, we have to report to the reportable transactions. That means the suspicious transaction as prescribed. This has already been prescribed by SRBs also and FIU. And that in the same format, we have to report to our institute. We have to internally establish and having a proper policy and a procedure mechanism has to be evolved for prevention of money laundering and terrorism financing and proliferation of the financing. We have to have an internal mechanism for certain type of transaction as defined, which we read in the earlier slide about the transaction, and furnish this suspicious transaction. It is our duty to have the designated director and principal officer in case of firm. And in case if you are a sole practitioner, then you yourself can become a principal officer designated for this purpose. Then there are certain rules and responsibility specified in these guidelines, which I am not detailing, but there are detailed roles and responsibility given to the designated director and principal officer. While taking the employees, we have to have a proper screening procedure while hiring, and we have to train them and guide them about the mechanism and policy procedure for onboarding of our client or due diligence, or have very alert and I mean, they have to be very mindful if they come across any kind of a transaction which raise some suspicions to a reasonable normal person. Of course, we have to review periodically all the policy procedure control with the change in the law, change in your clients, change in the jurisdiction, the change in kind of a transaction which are happening. So periodical review is very important. You have to have a KYC norms. RBI has already given a KYC norms to the banks and financial institution. Similarly, KYC norms maybe institute can develop, or we have to have our own KYC norms and have the robust mechanism. So our employees also understand what kind of a document they have to ask if we are onboarding a company, foreign national, foreign individual, I mean foreign entities, or a trust. What kind of a document we should ask for. Similarly, client due diligence norms, enhanced due diligence norm. Enhanced due diligence is required when the transaction is coming from the high risk, maybe high risk transaction, big volume or transaction. Jurisdictions are also like Cyprus, Cayman Island, or something like where it's not a FATF recommended or jurisdiction. Person who are maybe as you have to be alert about dealing with the person, whether they are in the social media also, how their background is. You have to do some background check entities also. Then counterparty screening, prohibition of tipping off. If you are informing to our institute about the suspicious transaction, you cannot tip off, or you cannot inform your client that you have filed already with the institute. And not only after the filing, but before filing, during the filing, and after the filing also, you have to keep everything about silent and secret. You can't tip off up to your client. Next obligation is to maintaining the records and up to date and accurate report for 5 years. That's the law. Act says that 5 years after the engagement is closed. If your engagement is closed, that doesn't mean that transaction must have happened 5 years, but engagement is just closed, and you have to keep all those records also. 15 is a risk assessment, risk-based approach, and allocating a right resources for oversight of this kind of a safeguard. You know who are the employees who are really need to be allocated for some high risk transaction, enhanced due diligence to be given. So those kind of resources you have to allocate for risk-based approach. To sum up this obligation, I've just mentioned again, though at the cost of repetition, I'm just ensuring that this slide will be helpful. Register first with the SRB, develop practices and policies and control for relating to money laundering and terrorism financing. Client due diligence and customer acceptance. Based on that, you either do not accept, refuse if you have a doubt. Not necessarily all clients should be accepted if there is some suspicion. And enhanced due diligence, regular customer also you have to review, and counterparty screening also to be done. If your customer is dealing with the third party and you become a party for that transaction, it is your duty to see that counterparty screening also to be done. Same way the screening procedure to be developed, that which kind of employee you will hire, how you will train them, what kind of transaction monitoring, how frequently your internal audit will be happening for ensuring that the policy procedures and controls mechanisms are also functioning in proper at the ground level. It may not be just on the paper, but the checks and balances should be done by internal audit. Reporting to the designated director and principal officer. Even if you have a branch across India, then at each branch level also you should have a compliance officer who is aware about what kind of diligence he has to be taking care under PMLA. You have to communicate all designated directors and principal officer to the director of IU through, of course, SRB, reporting through SRB, documentation for 5 years after the closure of engagement. So now identification of suspicious. Some question comes that how do you know that this transaction could be suspicious? So there are some tricks and methods. I mean, as a chartered accountant and cost accountant, company secretaries, we are all aware some kind of economic benefit to follow. And so examples, I have just placed some example, like suppose loans that have been granted without any proper due diligence. Any person asks for the loan and you just give without KYC, without appropriate guarantees, collateral, securities, and there is no commercial rate of interest, or there is no repayment period also mentioned. That means for sure this money is not expected to bring it back. It is just kind of a sham transaction showing it as a loan. So that gives some suspicion. Second is a having a power of attorney given to a number of individuals, and which is very wide power of attorney, that they are allowed to do anything on behalf of an entity or a person. That gives some doubt that he is stepping in the shoes of the person. Third is a large amount of cash is deposited, maybe in the small portion, or at the same time when the company was a dormant, the account was dormant for 5 years, and suddenly there is a huge amount of 50 crore coming into that company's account, and we have to ask and some more detail. Unexplained payment from the third party. There is no invoice, but the money has come, and you have no idea that how this money and against what payment. There's unexplained payment. There's use of multiple foreign accounts being used by your entity or client. Transaction which is inconsistent with the customer's business profile. Your customer is a manufacturing, and suddenly he is doing transaction for some power or some extra XYZ gold, and you will doubt that it is not your main business. So why are you doing? Similarly, deposit and transfer of funds without any specific justification. Uh, any customer for whom you cannot determine the true ultimate beneficial owner. They are not disclosing that who is a UBO or SBO, significant beneficial owner, as we know, more than 10% holding, or there is a foreign entity. So there is a separate beneficial ownership rules are also mentioning. Companies Act also has a mention about it, and LLP also you have to have a beneficial ownership detail. Payment from countries considered high risk of money laundering or terrorist financing, and frequent change in the name of company. Directors are changing very frequently. Guarantors are changing. These are some kind of identification. Just for the sake of explanation, I am just putting it that these are all considered as a suspicious transaction. On October 11th, the institute has given, not in December, Rimjim, it is on October 11th. Institute has given a circular to all the members to report as a reporting entity if they are dealing in such kind of a activity or financial transaction. And there's a portal has been developed, and a reporting form is also being developed. So they have to fill the form. So ICSI has also advised that there is a Ministry of Home Affairs who has given in public domain that certain kind of organization and individual are banned for doing any kind of transaction. So if you are forming, maybe you're creating a DIN number, taking a director's identification number or digital signatures of anybody, or opening a new company with the subscription money of this individual, you have to be main watchful. You have to secure and see from the link which are updated very frequently by Ministry of Home Affairs, and see that you do not deal with such kind of organization and individual. For unknowingly, knowingly, you become a party for the proceeds of crime. On 17th October, again, Ministry of Finance has amended the rules and widened that in case the implementation of policy for the group. So suppose there is a NBFC company and the entire group or the banks. In that case, there are a number of entities in the bank, securities, finance companies, or the bank corporation. The group-wise programs can be having, and group-wise sharing of information of client to each other. So that's the implementation of policy by group is allowed and mandated. Reporting transaction should be immediately by fax and email. It's not that you deliver by post or anything. The information of transaction, which are suspicious transaction, to be given by fax and email. Keeping such report confidential, like no tipping off. In client due diligence, the threshold limit was 50,000, and additional responsibility is given to the RE. And this additional responsibility is very huge, like identify its client, verify their identity using reliable and independent source of identification. That means you have to Google it, search it from social media, find out who are this person, if it's a walk-in client, if it's not your retainer and there is a new client and you are not aware about his background, you are obliged that if you are doing in this kind of an activity or financial transaction, you have to be mindful and find various source to find out then who is that person, what kind of relation he has, who is the ultimate beneficial owner, because this responsibility is come on the 17th October notification. Also, you have to take a reasonable steps to understand the nature of the customer's business, his ownership, and who is controlling the business. So you have to be very watchful. It's not that I don't care who is. I'm just doing that one transaction. But for doing that one transaction, you have to be mindful that you have to be aware about customer's business, who is taking the shot, who is the deciding person, and how the ownership is accordingly. It's a complex transaction. You have to be more mindful. Determine whether the client is acting on behalf of a beneficial owner. Identify who is the beneficial owner. I think this is the most important to find the source of identification of the person who is taking the shot. And additional client due diligence measures will also require about your existing client based on your materiality of the transaction and risk. Though he's your regular client, but suddenly he is doing a huge transaction, which is very material and which may be risky. Suppose your existing client is giving loan to 50 crore to a company in Cyprus, in Croatia, and you are sure that money may not come back. It is a risky transaction. So you have to have some kind of information available, and the amendment is in the red line. It says that such information or data collected under the client due diligence is to be kept up to date and relevant, particularly when the risk is high. You can't say that it was my already existing client, but the transaction is new and it is risky and it is material. So this responsibility is given on under the 17th October notification. Again, as a reporting entity, RA is a reporting entity. They have to formulate a client due diligence program depending on the financing risk and the size of the business. They have to take and accordingly change the policy control procedure, guide and inform senior management if the transactions are happening. So the junior or your employees must be properly trained that such kind of risk is coming. They have to immediately report to the senior management. Now, what are the steps to follow we as a professional? First, do our KYC properly. Uh, with an open mind, as I put in the first slide, second slide, keep it on open mind, research everywhere, find out if there is a red flag. Be very careful. Either you do not accept the assignment and say no, or you do extra enhanced due diligence. Ask for the clarification from the client. Ask who is the person, and do not tell them that in case if after finding and clarification received, you are still not convinced and you are finding it is a suspicious transaction, you report to the institute but does not tip off the customer also. Similarly, you evaluate later on after collection of all information whether you should go ahead with the transaction, whether you should report, you should not report. or you should immediately say no to the transaction and report to the institute. And if it suggests that there is an involvement of proceeds of crime, that's our responsibility as a responsible professional and taking care of the interests of the nation also. We have to report to such transaction in 7 days by email or fax immediately to our institute. No tipping off and record to be kept, whether you are concluding the transaction or not, because it is transaction or attempted transaction. You have to keep the record. Don't discard the record saying that I am not taken up the assignment, so I don't have to keep the record. Keep the record if you have reported to the suspicious transaction or otherwise also. Keep the record, maintain the record, and ensure that your STRs are filed. It doesn't make you into any kind of a discomfort position. Either you will be treated as a criminal because you are assisting to the nation, assisting to your institute, and filing and recording that maintain the confidentiality, and you will also be protected because you are not dealt into the transaction, but your reporting would be your duty. So is it worrisome to a PCS? Yes and no both. When it becomes worrisome, and when we become a reporting entity, 4 steps we have to see whether there is a financial transaction which has been defined under the 3rd May notification, whether are we carrying out that kind of a financial transaction. Are we a company secretary in practice? Definitely then employee company secretaries need not worry. We are doing on behalf of our client and in relation to the notified activities which is defined under the 9th May. So we have to see financial transaction as per 3rd May notification, notified activities as per 9th May 2023 notification of Ministry of Finance. So both we have to take care. And otherwise there is a penalty and fines, imprisonment, concealment, cancellation of our license by our institute. So we have to be vigilant company secretary. As Rimzim also said, we are a gatekeeper and company secretaries play a very crucial role in formation of company, any kind of a corporate action, capital inbuilt, many things. So we have to have a inbuilt proactive measures. Like data protection also is a far away. We are not still, but many company secretaries, PCS, everybody are ready with the data protection. Whereas PMLA, it's a yesterday basis because it's already been notified in last year in May 2023, we are already late. So if you are dealing, please take a proactive measure and ensure such kind of a guideline, standard operating procedure, SOPs, training program, manuals, everything is to be documented, drafted, and kept ready. And that's very much important for the global effort. I'm just shooting out to 5-10 minutes more. If I'm allowed, I'll just go through the SEBI, just touch upon. Otherwise, I'll skip that also. SEBI has also given a master circular in June 2026 recently, overriding the all other earlier circulars for the AML, CFT, and obligation of security markets and market intermediaries. They have to have essential principle, policy, procedures, and their obligation. Everything is detailed in this guideline, though it is not my subject matter today because I have to touch upon only AMT and I mean that guidelines. But I'm just giving this slide uh, as a SEBI guideline. So registered intermediaries and the branches and subsidiaries outside India, stock exchanges and registered intermediaries, they all are applicable. Registered intermediaries are down here. I mentioned here stockbroker, share transfer agent, bankers to the issue, that is merchant banker, trustees, registrar to the issue, AMC companies, asset management, depository participant, merchant banker, portfolio manager. All these people are also required to comply with this guideline of SEBI. What kind of procedures and policy they have to mention, I have just documented here. Group-wise policy also recently, 17th October amendment mentioned that they have to share internally, maintain confidentiality. These are the compliance requirement by them also, same group-wise, understood by the staff members, properly trained, regularly review client acceptance policy, client's due diligence procedure, awareness programs. All these are also similarly compliance requirement. Client acceptance also is a detail whether you should accept and what are the document you have to maintain for the client acceptance. I'm not going through in detail, just touching upon. And they have to report directly because registered intermediaries are not required to have a SRB. They have to directly report to FIU. And the reporting are also here mentioned. Now, power of central government under unlawful activities also, the power of central government is to say like freeze, seize and attach, prohibit those entities and individual and prevent the entry or into a transit through India. Similarly, under 12A of prevention of This 12 of WMDA, that is Weapon of Mass Destruction Act, that also have the central government has the same power. Now some FAQs, I think Deepa or Priya, sorry, Pooja, can I touch upon these 4 or 5 questions I have put? 4 only.
Yes, ma'am, definitely.
So whether a practicing CACS cost account engage in the incorporation of the company as a capacity of a professional for client required to register, answer is no. If you are just not a reporting entity, if you are just giving a declaration under Section 7 of the Companies Act about the compliance of the procedural part for incorporation of the company, you do not become a reporting entity or a relevant person. Second question is whether the professional making payment just for incorporating company required to register. No, you are just getting a reimbursement. You are making the payment on behalf of the client and you are getting reimbursed for your government dues and legal dues instituted, and notification of 19th May also was 9th May is also very clear that you are not considered to be a reporting entity, and you are not required to register on the PMLA portal of institute. Third question, are attestation service and audit services are also covered under the purview of reporting entity? No, they are not covered because that's a core service activity of ours. We are not entering into the financial activities or any kind of other activity which has been mentioned under the 9th May. So these services are not under the purview as a reporting entity. Last fourth, if we are as a practicing professional is not rendering any service mentioned under the notification of May 3rd and May 9th, then do we need to register? No, you don't require to register if you are not a reporting entity. We have our article, you can go through our link, and I think I'll just give last my wording that there is no fear. We should not be fearful of dealing into, but we have to be more vigilant. We should not get into the step or shoes of the our client and do financial activities on their behalf, or run their bank account or manage their account or operate their demat account also. We are gatekeeper and we have to be more vigilant, and we should have still have the policies and procedures and manual for our employees, our juniors to handle any client. I think that's it. Thank you very much. There's one question. Madam, can you be a bit closer to the mic? Is it for me? I don't know. I'm so sorry.
We actually had some issue with your voice. We were receiving a lot many queries on that, so I just tried to communicate with you.
Oh, so and I just saw the chat. I'm so
No
sorry.
issues, no
I was
issues.
audible during the.
Yeah, you were audible.
Okay.
Otherwise, I would have told you.
Okay. I think that's all. Broadly, I've just touched upon the sensitive points for our members. That yes, you have to be more vigilant, and we'll be happy to take question answer. And I will request Rimjim to clarify on the formation agent, if she can.
Rimshi ma'am, are you there?
She's on
I
mute.
don't know maybe whether she's not around, maybe.
No worries. We can, if there are any question answer.
I would like to take a few questions with you, ma'am. Our members, matlab, the way they have given their queries, I guess they are into reporting. They want to know what their responsibilities are. They want to do it right.
We already put in the presentation that if they become a reporting entity, they have to go through May 3rd and May 9th notification of 2023 of Ministry of Finance. If they are doing that financial activities on behalf of their client during the course of their profession, then definitely they become a reporting entity. They have to register with the institute immediately. The form is already given on the portal. They have to fill that form and be mindful. They have to immediately on the day 0, when they become a reporting entity, they should have the policy, procedure, manuals for client due diligence, client acceptance, enhanced due diligence, recording, reporting requirement, everything they should be ready with. Or
Yeah.
till that time, they should not take up such assignment. And you have to be very careful because you are putting yourself into difficulty. If you suppose, for example, you are giving a register office of your company, without any benefit, definitely. If you are giving on lease, that's okay. But and when there is a TDS, because that's a specific exemption given under the notification of 9th May, that is an exemption. But you are giving your director, you are becoming a director in any company without knowing, and you are putting yourself into difficulty. You are managing the assets and bank account of any company. and inward remittance is coming, you are not aware what is happening, and you will be questionable, you will be questioned, and you are answerable for that all transaction, and you are not aware what kind of a client ultimate beneficiary. You yourself is not aware. You feel that this is what, and there are complex transactions. You do not have expertise. Do not put yourself into more difficulty. For the young PCS, if they are not aware about the complexity of the transaction, because certain transactions are so complex that you need some experience. You need to ask relevant question to your client company to find out who is the ultimate beneficiary and where from the money is coming and for what reason and what are the documentation. You should call for all the clarification from your client. If they are hesitant, stop there. It's okay. It's okay to not to earn rather than putting yourself, because PMLA is not an easy, it's a criminal offense. And it is putting your career, your license, your hard work of number of years of your practice. Everything will go if you are not very vigilant and alert.
True.
But
No
day
doubt.
one, you have to have your policies and procedures and manuals in place. Because that's just ICSI, the SRB will also ask you. They can supervise on-site and off-site. The power is given to ICSI by the notification that they have to be mindful. Then the committees are there. Nodal officer can ask you anytime, where are your internal policy? What will you show? So that's how I think you have to be very ready with the all this
And slowly and
information.
gradually, that responsibility is sinking in amongst the professionals. When they're raising queries, they're raising questions whether I am eligible as a reporting entity, whether I have to register for that, what are the procedures. So that means somewhere that understanding is sinking in amongst the professionals that they have to do certain obligations. They
No,
have to undertake those compliances.
if you are just forming, I mean, most of the clients or most of my juniors also are asking me query if I'm a I'm just for formatting agent because I'm considering I'm a formation of a company. Am I a forming agent? Answer is not very clear, but there is a clarification that you are just being a part of the entire facilitating to form a company. You are just giving a declaration of compliance. You are paying the government fees and the client is paying you your fees. You are not a reporting entity. You
Right.
become a reporting entity if you are doing a financial transaction or a notified activity.
And that too on behalf of the client by your own self.
Yes, yes. You are putting your, I mean, you are stepping in the shoes of a client by a power of attorney. On their behalf, you are doing everything. That means you are responsible for your action. So do not have take such a wide power of attorney that you are allowed to do anything on the earth for this company, for any immovable property acquisition, selling and buying. They will be very happy. You take care and we are paying you X number. That X number of amount is not important, but your responsibility, you are putting yourself into a difficulty because you are a decision maker now on behalf of your client. At the
Hmm.
same time, you are not aware about the complete picture of transaction. You are not aware of who is the final take person who is taking the who is the beneficial owner, who
Right.
is taking the decision on behalf of somebody. You feel that you are just doing something, but you are not doing. You are a power of attorney holder. So, if there is a specific question on the chat box, happy to take.
Ma'am, the very first question that I received is whether under the definition of reporting entity, is AIF also covered?
AIF is otherwise also covered because under the SEBI Act, it's a part of the intermediaries. SEBI registered. So they are part of SEBI guidelines and they are reporting entities. Because they are client onboarding, no? They are also party to that. So if any entity which is registered under Section 12 of the SEBI Act, then definitely they are the reporting entity.
Okay. So the second question is, after an NBFC is registered as a reporting entity under FIU India, what is the mandatory reporting requirement which needs to be complied with?
That RBI has given a detailed notification to all the financial activities, including, I have not elaborated to put, but I have put a link. So there is a master circular by RBI, wherein the obligations and reporting requirements having the same kind of KYC, client due diligence, regular review, enhanced due diligence, reporting, suspicious transaction, all these are very common under the Act and by the RBI policy also. Similarly, SEBI guideline also says the same thing. So these are the, yeah, there are number of obligation, not tipping off, confidentiality to be maintained, reports to be maintained for 5 years till the transactions are over. So these similar obligations are there under the RBI for NBFC also.
We have people who are very curious about getting into the course on AML. They want to learn more on PMLA. Could you guide us on that?
I think it is very simple law. One should read definitely, because we have to be a party, or we are a professional who are running into the economy, and we should be aware what is happening in the finance, in the investment side, and the security. Now, of course, the gift city is also more, and AML is also separately dealt with even in the IFSC also. Every regulator has to be vigilant about the money laundering, cyber security, terrorist financing. These are all the requirement where the professionals are required, and very few professionals are expert in that. Definitely this course should be done, but I think there could be separate course on NISM, or maybe institute can come out with such kind of a course to give the expertise to our profession, our members. They can be expert, they can, I mean, separately for the RBI notification, SEBI expertise also separate. But overall PMLA and the rules require one should be very, very vigilant, and what kind of obligation we have to be ready with. And of course, we have to develop our own policy, procedure, manual. We are also developing in-house a separate checklist that what we should minimum ask for onboarding any client, foreign companies coming. We definitely ask the certified true copy or the notarized copy, and a postal copy of their charter document, where they are, what kind of reporting they are doing into their host countries. Everything you should have. You should don't simply just accept any kind of a transaction or any kind of a client. You have to be having a choice of client acceptance. Even to your junior, you should train them. So that's
Regarding the course, I just remembered that last year we had launched a crash course on PMLA.
wonderful. That you
Yeah,
should revive. I think now the 3rd May and 9th May notification, many professions are covered under the net of PMLA, directly, indirectly. I mean, so far we were always thinking the proceeds of crime, in crime we are untouchable. Like as a professional, we don't
exactly.
deal in that. It is a area which we don't deal. We are not into the finance also. But now we, as a professional, are forming a company also, or being a director on some company also. You have to be more vigilant. Except you are an independent director, but being a giving a simply nominee for any client, that I become, okay, I am a nominee of XYZ foreign company here, it would be also risky. Nominee shareholder also will be risky. You will, I mean, one has to be very careful and vigilant. Nothing scary here, but you cannot have a casual approach. You have to be mindful. What are you giving your approval for? Or accepting power of attorney, or dealing into the transaction of accepting that, okay, I will operate under demat shares, or I will take in my name these shares, or something like that.
There's a query which asks that regarding the dealers in precious metals and stones not being reporting entities,
They are,
not being reported entities, but registering an FIU portal.
they
So,
have
what are the compliances?
they have to be reporting entity, because that's the definition says that they are reporting entity.
So, in that scenario, they don't even have to register on the FIU portal.
They are reporting entity. They have to register directly on FIU and IND.
Okay.
There is no
And
SIU. So casinos, playing game of chance. We have mentioned earlier also precious stone and
the precious stones and metals.
yes,
Any
metal.
dedicated list of compliances for them?
Same transaction reporting entity, they have to do the same under the act. The rule describe all details about
Okay.
entire maintaining of records, client due diligence. Client due diligence also in the rule, it's mentioned very clearly. If it is a company, what kind of a due diligence you have to do. If it is a trust, if it is a partnership firm, if it is an LLP, everything is mentioned in the rule clearly, that what kind of information is required, what kind of a documentation you have to require for if they are the client of different entity. Everything has been detailed in the rule. And rule and act is not very lengthy. You
Hmm.
can easily do that, and learn on your own, and be aware when you are taking the transaction. But doing the crash course or such kind of a course for awareness is a need of an hour, I think.
That's true.
ICSI should do more such program also for awareness. Because when I was
Definitely.
talking earlier, people were just wondering what is PMLA. I mean, why? I mean, no interest. Honestly, unless they are from the financial intermediaries, they are aware. Like if it's a bank or NBFC, they are much aware, and or the SEBI registered intermediaries. But as a practicing PCS, we are just not that much aware because the Act is 2002 notified and enacted in 2005, so almost a decade and more, almost 2 decades. It's
But
very.
then again, it has been made applicable on us like just last year only.
So suddenly it's a boom. No, that's what I
Yes.
mentioned, that it is a boom. That why? I mean, I was also wondering what is a weapon and mass destruction? Where are we covered in that? How are we indirectly, directly involved? But when I read the definition and understood that relatable offense and relating offense, and where section 447 of the Companies Act, even if you don't believe, I mean, it's a company normal violation under the Trademark Act and Copyright Act also is covered under PMLA. So I think PMLA also needs some amendment. It may over a period evolve again. Certain which are very casual or which are not very much important economically, those can be dropped out from the violation of offense, which are scheduled under the Act. So but this offense, and it is a non-bailable offense and non-cognizable. So, I mean, sorry, cognizable and non-bailable. Also, we have to be very careful. So, a young PCS should definitely be little mindful, take a senior's advice, or do not deal if there is a complexity and a huge transaction, a different risk jurisdiction. Money is coming from Cyprus or Africa or Nigeria, and you are not aware who is the beneficiary. Don't involve in such kind of a transaction without giving a enhanced due diligence.
Although we have covered this during the course of this presentation, there's a question that popped up that how can we maintain a balance between reporting and the business interest of management? What can be the tips which will be of help for maintaining the balance and being compliant?
No, balance, as I told you, that you have to maintain the balance by first take a KYC, do proper KYC of the client and client's business. You should be aware. Keep your mind and eyes, ears open on the social media. If there is anything you are hearing for your client and the transaction which is happening, you are aware that something is cooking up, and do not be a part of that. You maintain the balance by definitely first KYC separately. Second is asking more relevant question and getting the detail from the client for clarification, and do your evaluation. That's a step which I have mentioned in my presentation. Do KYC, ask for the clarification, and do your own judgment evaluation, your gut feeling. Even if you are an old client but you feel that something is not, now the new management is come or the new person is doing something and you are not comfortable, definitely ask question, convince yourself, have the gut feeling. And if you find that suspicious, definitely document everything properly. Do not certify, do not advise unless you are pretty sure that everything is transparent, you are giving equal importance, and you know who is the beneficial owner for any LLP company. See the records, everything is public domain, it's open, no? So you have to be more aware that they are not a willful defaulter, they are not into the list of the Home Ministry under the terrorist money. There are certain organizations which are not to be dealt with. Are we dealing into that? You have to be more careful. So there is a balance only by using your own wisdom, using your own practice, setting up your policies and practice. That's how it will come.
And I'm picking the next question, a bit longer one. So I'll read it out. Section 32A of the IBC plays a key role in conflicts with the PMLA. It shields the corporate debtor and its assets from actions under other laws, including PMLA. Hence, conflicts arise when the IBC and PMLA have competing claims on the same assets. This often happens when secured creditors with legitimate claims on assets clash with PMLA enforcement agencies, seeking to seize them due to suspected money laundering. The situation escalates further when lenders finance assets targeted by PMLA authorities based on alleged offenses by the owner. Court rulings paint a nuanced picture of the interplay between IBC and PMLA. While the IBC, particularly Section 32A, often takes precedence during insolvency proceedings, exceptions exist. Promoters and directors implicated in PMLA offenses remain liable. Do you agree that a balance needs to be struck between IBC and PMLA and a coexistence and fostering is the need?
Yeah, I think PMLA, IBC generally is a overriding for many, but PMLA is exception, I think. That's what my knowledge goes, though I am not very updated on IBC. I don't do any CIRP process. I do more voluntary liquidation. But I think as far as what I understand is PMLA Act is a separate special courts are mentioned and separate. Even the police can't do that, regular police. And PMLA is a more serious offense. Criminal activities are involved. So a balance is required definitely, whether which supersede. And if the property belongs to under the same enforcement director and the claim is here also, I am not the right person to answer this, but I think the balance is required to be between the IBC and the PMLA. Because the question is pretty long, and I understand what she's coming or he or she's coming from, that the same claim and both the agencies are in
Yes, yes, yes.
insolvency. So which will, but I think that we have to find the law. I'm not very updated on the law of IBC, whether it
And
will.
it's more situational, I guess, not the same in all the cases.
So legally also,
Rule
whether the
works.
IBC exempt, IBC can't overrule, as far as my understanding was PMLA
Yes, sir.
supersedes. And though generally IBC supersedes all other act for procedural part, but PMLA, I think that's my guess. I may update myself on that, and maybe I'll reply later if I have a different answer.
In case if there is no suspicious transaction, even then, does a financial institution need to file any nil return to FIU?
No nil return is required. If you have a suspicious transaction, then only you have to report. There's no nil return. It's not a reporting just for the sake of reporting. If there is a transaction and there is a suspicious, then only you have to report and document it. No nil reporting. There is an FAQs also on that by SEBI and RBI, that there is no nil return to be filed. One has to update the FAQs also.
Is it feasible to report transactions reported to NHB and FMR1 returns under STR transactions to FIU as well?
You can as a practicing, but your duty is only towards the SRB, ICSI, because ICSI has a nodal officer. They will scrutinize first whether you have a certificate of practice, whether you have done this and that, and then in turn, SRB are responsible for the supervision and monitoring. So I don't think we should do directly with the FIU and put ourselves into difficulty. Our duty is only to the SRB institute, and we should report to the institute. If you want to go ahead, you can, but fax and email to institute would be good enough, because ICSI as a nodal, or they have appointed a nodal officer. There is a technical head of the technical committee also. They will take the call. They will decide what is to be done in the next, instead of you doing. But no harm in doing. But I would not do.
There's this one question which even I was resonating the thought with. It says it seems difficult for a small CS firm to have all the policies in place and have robust mechanisms. Somebody who's working individually, how do they go about doing it?
They have to, there is no choice. You have to be aware about, and you don't take the such kind of a transaction where, why are you putting yourself into the financial transaction? There are activities and financial transaction which we also don't do. I'm also not so far reporting entity. The small person may not require. I'm not saying that I'm the senior and I'm the higher, but I'm just saying that mostly don't enter and put yourself into such kind of a situation where you are doing that financial activities or doing the notified activities. 3rd May and 9th May are the only descriptive detail where if you are doing that transaction, you will be a reporting entity. So I don't see the small time PCS who is an individual should enter into such a complex transaction or take such kind of a power of attorney or such kind of a liability and responsibility, knowing that he's alone. So he should not do that. In case if he wants to, he can definitely do. He himself can be a principal officer, and he himself has to set up all the policy, onboarding of client, maintaining the record, because he doesn't have the employee. So there is no employee training and hiring and manual and all, but at least he should have a client KYC, due diligence for the client, and the enhanced due diligence documentation, that what he has asked for, what kind of a document, that is a reasonable person or normal professional will definitely ask before putting himself into a transaction or doing that kind of a work. So nothing more difficulty he will face except documenting that on.
That's the entire thing for us.
Yeah, but that's how I think you have to put yourself the question as a reasonable professional. We are the gatekeeper and we are the professional to support our clients also, but we are part of our nation building also, and we should be supporting our government or our regulator, that we should not be party into such kind of illicit activity, illegal activity.
As they say, governance and compliance begins at home.
Yeah, I'm not saying it's a most difficult thing or we should not do, but we should be more aware. We should be more knowing what is happening, and we should be able to analyze and evaluate that this is right. And I have a reason to believe that these are proper documents and these are the client is very transparent. He has given me all detail. It's not everything is bad. Every complex transaction is not necessarily be a difficult and a suspicious transaction. But whenever there is a difficult transaction, suspicious transaction, you should be more alert and more mindful. Ask more question, gather more document, because in some document it will come up that no, this is where there is a click that it is not going right, or this is unreasonable. There is no economic sense of doing this transaction. As a reasonable person, you definitely suspect that.
One last question. Whether law firms who are providing directorship services are covered as reporting entities. For example, through a law firm, a company is getting a resident director.
Definitely. They are reporting entity under the new. Though the law firms currently, I have not touched upon that, but only PCS, I mean, 3 Institute of Company Secretary, Chartered Accountant, and a Cost Accountant are covered. But I think the time is not far that advocates and law firms may also be part of the AML. Currently, they are not. That's very right. And but still, they have their own due diligence process. I'm not saying the law firms currently not covered. That doesn't mean that they are just not vigilant. They will be mindful what they are doing. But yeah, currently they are not reporting entity.
That will be all from my end. Any concluding remarks?
Nothing. I think this is the first program on the national level which I am be party to that. Maybe some error from my side. I'm just sorry for that. And some my PPT is also available. And last question for the young PCS: just be mindful. You should not put yourself into difficulty, because many foreign companies, investors are coming, and you feel very excited and enthusiastic. But at the same time, you should be little mindful. And reach out and read more. PMLA Act and rule is not very difficult and easy to understand. So not a rocket science for anyone. Thank you. And thanks a lot, ICSI, for giving this opportunity. And I hope this would be a little useful to our PCS members from my side. Thanks a lot.
Thank you, ma'am. And thanks to you and Rimjim, ma'am. She had some urgent business to take care of, so she had to leave in between. But our heartiest thanks to both of you for this engaging session. The way you guys, you both have given us an insight into PMLA, all the nuances. It's like a huge burden has been taken off from our heads as to how things have to be done. Thank you so much, ma'am, for being with us.
Thank you. My pleasure. Bye-bye.
Thank you.